Good morning. Good morning, everyone. Welcome to the Committee on Environment and Public Works. Happy to be here with all of you. Warmly welcome our witnesses and others in the audience. Senator Capito, good morning to you and other members of our committee. There's a lot going on in the Senate today. You probably don't believe that, but there is. Getting stuff done, and I think just about every committee is meeting right now. And so we'll have people coming in and going. But there's a lot of interest in the issues that we're going to be discussing here today. We appreciate each of you for making the time to join us after a grueling Thanksgiving holiday. I hope you had as much fun on your holidays as my family did. But today we're here to discuss the U.S. Army Corps of Engineers Project Partnership Agreements. And what exactly are project partnership agreements? I don't like acronyms a lot. EPA is okay, but sometimes people get carried away with acronyms. So I'm going to ask you to refrain from use of acronyms for the most part so I can understand what you're saying. Sometimes people get carried away, but sometimes we get carried away. But PPAs are documents signed by the Army Corps of Engineers and non-federal project sponsors that guide work that's authorized under the Water Resources Development Act, affectionately known around here as WRDA. And these projects are critical to coastal and inland flood risk mitigation, navigation, and ecosystem restoration, among other purposes. I also say they're critical because one of the major roles of federal government, and state governments as well, as I say that as a recovering governor, but that one of the major roles of government is creating a nurturing environment for job creation, job preservation. And what we're going to be talking about here today is one of those major ingredients for creating that nurturing environment. I'd like to help people. I think one of the best ways you can help folks is certainly make sure they have clean water to drink and clean air to breathe, but also to make sure that they have a job so they can support themselves and their family. As many of us know, despite the Army Corps' exceptionally important and challenging missions, the agency's funding needs far outweigh its available resources. So why does this matter? Well, the projects carried out by the Corps provide the backbone of America's water infrastructure. That work includes protecting communities from damaging floods, enabling billions in commerce through our ports and through our waterways, and restoring hundreds of thousands of acres of aquatic ecosystems. Corps projects also help prepare communities for extreme weather events, which we know are getting worse due to climate change. And the importance of that work cannot be overstated. For example, NOAA, National Oceanic and Atmospheric Administration, estimates that the threat of sea level rise is going to accelerate in the next 30 years if we don't do more about it. That's certainly going to impact many of the roughly 40% of Americans who live in coastal counties, including my own. In addition, the 7 most destructive storms since 2000 have cost American taxpayers over $1.3 trillion. Let me say that again. I didn't read this. I didn't believe this when I first saw this. So my staff, go check that out. 7 most destructive storms since 2000 have cost American taxpayers over $1.3 trillion. These storms destroy homes and cars. They grind travel and tourism to a halt, oftentimes uproot people's lives, not infrequently take people's lives. Corps projects are there to defend against these disasters. Corps projects also help keep our economy moving, as I was saying earlier. The Corps is directly responsible for operating America's water highway, a 12,000-mile-long system of inland waterways that are vital to domestic and international commerce. Most of the markets for the products that we create in this country are not in this country. They're outside of this country. And the way we get, for the most part, our products to other places, we send a lot of stuff by air, but mostly it's on the water. And the waterways that the Army Corps helps make available and the ports that they help enable are critically important. Each year, the expansive system, that 12,000-mile system of inland waterways, moves more than 500 million tons of commodities, 500 million tons of commodities, including 60% of our nation's agricultural exports. The Corps' work to help operate and maintain that system results in an economic benefit of nearly $14 billion, billion with a B, each year. Given the range of benefits of core projects, it should come as no surprise that the reauthorization of WRDA continues to enjoy broad bipartisan support. We do a lot of here in this room in a bipartisan way. Senator Capito and I subscribe to an aphorism that I think I heard from a guy from Wyoming that said, right there where you are, Mr. Hague, and he, as he said in his testimony, his confirmation hearing, he said, bipartisan solutions are lasting solutions. Bipartisan solutions, I believe that with every fiber of my being. But our most recent WRDA passed the Senate in 2022 by a vote of 93-1. 93-1, that doesn't happen every day in the Senate. It happens almost never in the Senate, but on a roll call vote at least, but 93-1. And that piece of legislation, that WRDA legislation 2 years ago, ended up carrying with it to the President's desk the National Defense Authorization Act, which the President signed into law. It's like WRDA was a locomotive, and one of the cars that was pulling was the National Defense Authorization Act, which is a huge piece of legislation. Ranking Member Capito and I intend to continue this bipartisan track record with WRDA 2024. We're soliciting the input from literally every single senator, every state that's represented in the United States Senate. And our colleagues have been great to provide us with plenty of input. But as many of you know, the bill is currently under development, thanks in no small part to robust input from many of our colleagues. And Senator Capito and I intend to move it through our committee before next summer. That brings us to today's discussion on the Corps' project partnership agreements. Corps' project partnership agreements. And since kicking off WRDA 2024 process in July, Senator Capito and I and our staffs have heard concerns that these agreements can be stalling critical construction projects, and we need to understand what's causing these delays and what can be done about it. As I stated earlier, a project partnership agreement is a guiding document between the Corps and a local project sponsor that outlines both the federal and non-federal stakeholders' roles and responsibilities for the construction and long-term care of the project. Since 2012, the Corps has dramatically changed the project agreement process, developing templates, streamlining requirements to provide consistency and fair treatment to stakeholders. Having said that, not every Corps project is the same. Stakeholders have raised with us, probably every member of this committee, have raised with us that these agreements need to be made more flexible and that many of the requirements are cumbersome. Yet, given the importance of the Corps projects for the safety and well-being of communities, non-federal sponsors feel pressured to sign unfavorable project partnership agreements. Ultimately, it's our job in Congress to ensure that federal investments are protected. At the same time, we must also ensure that non-federal stakeholders can support the projects and are made to assume and not made to assume an unreasonable amount of risk. Having said that, we look forward to hearing from each of you. Some of you have come a long way, and we're grateful that you've done that, and we're looking to hear about your experiences in working with the Corps to develop and implement project partnership agreements. We also look forward to hearing your perspectives on what is going well and where, as well as finding what we can do better. I say almost every day, everything I do, I know I can do better. I think that's true of all of us. And the idea here is to improve on what we've done before for many years. Before we do that, I want to yield to Senator Capito for whatever she might like to say. Senator Carper, we appreciate the opportunity to work with you and your team on this project again, and this is a great one. And I wish people around the country who think we can never work together, I wish they could see how this committee works, especially on this issue. Thank you.
Thank you, Mr. Chairman, and you're right. We do and have a great track record of working together on WRDA, and we're going to continue that as we move into the next year. So I welcome our witnesses. In my short conversation with Mr. Hague, I particularly welcome my fellow West Virginian. You need to hear this. He's from Charleston, West Virginia, and is a proud graduate of Capitol High School. So thank you for coming and being a part of this, as all of you, but a special shout out to my West Virginian. And if you didn't see it last night, which I know Senator Ricketts was was there. We lit the Christmas tree, the Capitol Christmas tree, the People's Christmas tree, which came from the Mon Forest in West Virginia. And I have just now thawed out from watching that because it was so cold out there. Anyway, since 2014, we have kept to the biennial schedule of passing bipartisan legislation that authorizes water resources studies and projects. WRDA also sets national policies for the Civil Works program of the U.S. Army Corps of Engineers, and I look forward to continuing that track record, as I said. This summer, Chairman Carper and I, and he mentioned this in his opening remarks, sent a letter to our Senate colleagues soliciting their request for WRDA 2024. Insight. Wait a minute here, I think I got my pages out. Yes, I appreciate the efforts of our Senate colleagues to submit their proposals for our consideration, and I'm pleased to say we received a significant number of requests, more than the last time, which demonstrates the strong interest in and necessity of this legislation. I've said previously it's important that any WRDA bill supports the timely and efficient delivery of water resource projects while continuing to meet national priorities. Flexibility is key to ensuring that the Corps can identify and carry out solutions that are tailored to address the needs and individual needs of our communities. Our nation's water resources challenges are diverse, and communities know more about their unique needs than the policymakers here in Washington. We must also continue to preserve the role of non-federal sponsors in the project delivery process and maintain the Corps' focus on its primary mission areas: navigation, flood and coastal storm risk management, and ecosystem restoration. Insight from our non-federal sponsors on their experiences with completed and ongoing projects helped inform what, if any, modifications are needed to the Corps' authorities. Today we'll discuss, as the chairman said, project partnership agreements, PPAs. In general, PPAs are legal documents between the Corps and a non-federal sponsor for construction of an authorized water resources project. These agreements describe the project and the responsibilities of each party. The Corps has undertaken efforts to simplify this process for executing PPAs by standardizing model agreements and issuing guidance for certain types of projects. The Corps also considers deviations from the model agreement on a case-by-case basis. However, federal law requires certain provisions to be included in the PPAs, limiting what modifications the Corps is able to consider in some instances. One of those statutorily required provisions is known as the Hold and Save Clause. This provision, mandated by WRDA 1986, requires non-federal sponsors to hold and save the United States free from damages due to the construction or operation and maintenance of the project, except for damages due to fault or negligence. PPAs also describe the operation, maintenance, repair, replacement, and rehabilitation, or O&M, responsibility of the federal government and non-federal sponsors. O&M responsibilities vary with project purpose. For certain projects, the non-federal sponsor will be responsible for O&M activities in perpetuity, regardless of the useful life of the project. Some stakeholders have indicated that certain required language in PPAs can delay the execution of these agreements. A delay can only extend the construction timeline and potentially, and probably would, lead to increased costs. This hearing will provide us an opportunity to learn more about these concerns and listen to proposed solutions. We'll also highlight how non-federal sponsors have successfully negotiated PPAs with the Corps. As we have this discussion today, it's important to remember that these projects require significant federal investment in order to be realized. Ultimately, we must assure that any changes to PPAs appropriately balance each party's risks. I want to thank our witnesses today for sharing their perspectives on this topic. I would say anecdotally that in discussing the topic of our hearing today, somebody said it's in the weeds. You know, it's very wonkish as to what we're talking about and how this is going to finally shake out in our WRDA bill. But I would say, as we look at the map of the United States, every project that's done, whether it's done through a PPA or not, is absolutely essential to the safety and the environmental prosperity of every part of our country. So if the weeds aren't right, the projects aren't going to be right, and the results are not going to be right. So I think that highlights how important a hearing like this is today, and I thank the witnesses for coming. Thank you.
Thank you for those words, and thanks for the great partnership that we've forged over the last several years. And I want to say to you, we're only as good as the people around us. We have great staff behind us, Democrat and Republican, and we're grateful for their work in bringing us all together today as well. I'm going to introduce our three witnesses, and we need a leadoff hitter, and someone with a famous name like The Hague. Have you ever been? Has anyone ever called you The Hague?
Yes, Senator. That's been a nickname at different points in my life.
I can imagine.
Yeah.
I can only imagine. I can't tell you some of the ones I've been called. But Jimmy Hague, Senior Water Policy Advisor for the Nature Conservancy since, what, 2016? Is that right? 2016. Mr. Hague leads the development of the Nature Conservancy's federal freshwater conservation policy priorities and coordinates advocacy across the organization's chapters. You've got chapters in all 50 states, don't you?
Yes, Senator.
Yeah, I thought so. We're glad you are here with us today and appreciate all that Nature Conservancy does. And please feel free to go ahead with your statement. Thanks. Welcome.
Well, Chair Carper, Ranking Member Capito, and members of this committee, thank you for the opportunity to testify today. I am honored to present to you the views of the Nature Conservancy concerning the U.S. Army Corps of Engineers project partnership agreements. And as Senator Capito noted, I am born and raised in West Virginia, and so it's an extra honor to be here in front of my fellow West Virginians.
Where were you born? Where?
In Charleston, sir.
Okay.
Yeah.
Good.
And I know you have great West Virginia roots yourself.
Yeah. Her dad was governor of my state when I was born. My sister and I were born.
The Nature Conservancy is a global conservation organization dedicated to conserving the lands and waters on which all life depends. Guided by science, we create innovative, on-the-ground solutions to the world's toughest challenges so that people and nature can thrive together. In the United States, the Corps is critical to achieving our goals for healthy and resilient rivers, lakes, and coasts. And the Conservancy has worked with the Corps on that mission through dozens of projects and programs across the country. We contribute scientific expertise on the use, design, and evaluation of nature-based solutions, assist with program implementation, and advocate for changes to modernize Corps procedures. The decades-long collaboration the Conservancy has built with the Corps has supported our conservation goals. The work we do together in communities across the country has improved flood risk resilience, economic development, and environmental protection, and my written statement includes specific examples of our work together with the Corps. And on a personal level, my work with the Corps has been some of the most fulfilling and rewarding of my career. I'm always impressed by the dedication and skill of its staff at all levels of the organization, both those in uniform and their civilian employees. And the Conservancy appreciates this committee's efforts to keep the Water Resources Development Act on a 2-year cycle every Congress since 2014, as well as your efforts in recent bills to emphasize nature-based solutions in the Corps' work. Your commitment to investing in and modernizing our nation's water resources infrastructure in a bipartisan manner has been critical to the success of our collaboration with the Corps. And the topic of today's hearing is an important one, since the regular water cycle you have established is authorizing new projects for study and construction and is guiding the Corps to build projects which deliver multiple benefits, enabling more resilient communities. And to achieve this goal, we should minimize the barriers to non-federal project sponsors who agree to share the costs of building water resources projects with the Corps. Unfortunately, we know of many project sponsors who feel the terms of the cost-sharing agreements are difficult to accept. Most Corps projects cost tens of millions to hundreds of millions of dollars. At a 35% construction cost share, non-federal sponsors must take on significant financial responsibilities for a project, even though the Corps retains ultimate control over many project design and implementation decisions. On top of that, some of the requirements of the cost-sharing agreements all non-federal sponsors must sign with the Corps create open-ended obligations for the non-federal sponsor. First, the cost-share requirement remains the same, even if projects go over budget for any reason, including reasons beyond the non-federal sponsor's control. Sponsors must cost-share any and all project cost overruns. Second, project costs become the sole responsibility of the non-federal sponsor after construction is complete, and the sponsor must operate and maintain the project in perpetuity. The uncertain nature of total construction costs and the unbounded commitment to operations and maintenance costs make it difficult if not impossible, for the sponsor to estimate the true cost of a project and manage financial risks. Third, the requirement in the cost-sharing agreement to hold and save the federal government free from harm creates unbounded and unquantifiable legal risks for project sponsors and can discourage them from agreeing to participate. Now, some of these requirements are rooted in statute, and they will need your leadership to change. Now, this committee has taken steps to address some of these barriers, including in last year's WRDA bill, and I urge you to continue with that effort. Now, given the variety of projects the Corps builds and unique local conditions and stakeholder needs, I urge you to consider a variety of solutions that will help sponsors contain their legal and financial risks. Non-federal sponsors need your help to rebalance how risks are shared between the Army Corps and the non-federal project sponsor of a water resources project. Doing so will unleash the power of potential local sponsors across the country to partner with the Army Corps to deliver more and better projects. Thank you for the opportunity to testify today, and I look forward to your questions.
Thank you for leading off for us. Next, we're going to hear from Kirsten Wallace. Ms. Wallace is on the board of the Interstate Council on Water Policy, which is committed to the stewardship of our nation's water resources. In addition to this role, Ms. Wallace is the executive director for the Upper Mississippi River Basin Association, and we look forward to hearing about your experiences, those of the association with the Army Corps. And before you give us your statement, tell us where are you from originally? Where'd you start your life?
I'm from Minnesota.
And now?
Minnesota.
You got it right the first time, right? Okay, good. Well, welcome from Minnesota, and your whole statement will be made part of the record. Go right ahead.
Thank you, and good morning, Chair Carper, Ranking Member Capito, and distinguished members of the committee. My colleagues and I are here to urge Congress to remove or modify unreasonable requirements that currently restrict or deter non-federal entities from participating as cost-share partners in implementing important water resource projects with the Army Corps of Engineers. We are grateful for today's opportunity to underscore the need to reform the Corps of Engineers project partnerships agreements, which govern the cost-share relationship between the non-federal sponsor and the federal government. We believe that a more equitable approach to these relationships will improve efficiencies in project delivery, improve partnership relationships, and stimulate the nation's ability to leverage non-federal resources. My name is Kirsten Wallace. I am the Executive Director of the Upper Mississippi River Basin Association, commonly referred to by its acronym UMRBA, which supports the states of Illinois, Iowa, Minnesota, Missouri, and Wisconsin in their interstate water resources planning and management of the Upper Mississippi River Basin. UMRBA is a longstanding member of the Interstate Council on Water Policy, and today I am speaking on behalf of the Interstate Council on Water Policy and its members. The Interstate Council on Water Policy was established in 1959, convening state and interstate water resource managers and planners from across the country. The Council evaluates policies affecting water resources management, develops solutions to commonly held challenges, and works collaboratively with Congress and federal agencies to advance those solutions. Many of the Council's members and partners, states, interstate organizations, local entities, nonprofit, and private organizations, collaborate with the federal government through the Army Corps of Engineers. As our nation faces enormous challenges to our water resources, we are even more compelled to lean into our partnership with the Corps to optimize our resources, our networks, our knowledge, and our ability to shape a future of prosperity. Our ability to partner with the Corps through cost-shared projects is challenged by the liability provisions that govern the partnership between the Corps and the non-federal sponsors. Project partnership agreements are legally binding documents that outline the responsibilities of the non-federal cost-share partner and the federal government for water resource projects. The key impediments include requiring the non-federal sponsor to assume complete liability for constructed projects, and operations, maintenance, repair, and replacement and rehabilitation in perpetuity. This results in a completely one-sided approach to the assumption of risk that is unsustainable for the non-federal sponsors to shoulder. As a spokesperson for the Interstate Council on Water Policy, our members want to share with you our conclusions that these issues of liability affect cost-shared projects nationwide and in all of the Corps mission areas, and that reforming project partnership agreements is in the national interest. The Association of Fish and Wildlife Agencies has created the map shown on the screen depicting the states for which their laws directly conflict with the liability provisions in the core agreements, the dark orange, or whether they have indirect legal barriers, the light orange. As I had discussions yesterday, I believe West Virginia should be dark orange. As many of 22 states across the country reported having laws against assuming the legal obligations required by the Corps. The Interstate Council on Water Policy is joined by several interstate organizations who are also actively working with members of Congress and the committee to explain the need for reforming the Corps' project partnership agreements, given the regional and local implications in their respective areas. These groups include the Association of Fish and Wildlife Agencies, National Association of Flood and Stormwater Management Agencies, Coastal States Organization, Delaware River Basin Commission, the Great Lakes Commission, the Interstate Commission on the Potomac River Basin, the Susquehanna River Basin Commission, Upper Mississippi River Basin Association, the National Audubon Society, Ducks Unlimited, the Nature Conservancy, the Theodore Roosevelt Conservation Partnership, and others. My colleague Jimmy with the Nature Conservancy spoke to these issues from a nonprofit entity's perspective. My colleague Bren Hass with the Louisiana Coastal Restoration Protection Agency will speak to these experiences in implementing PPAs. I'll speak generally to the issues affecting the states nationally. Indemnifying a third party, including the federal government, is in direct conflict with many states' constitutions and laws. It requires the non-federal party to promise financial resources for an indeterminate liability that may occur at an unknown time at an unknown cost for an unknown reason. Many state constitutions preclude agencies from obligating funds without an encumbrance against an appropriation and do not allow for incurring any indebtedness of any nature on behalf of the state until an appropriation for it has been made by the legislature. In addition, indemnification requires a state to assume liability beyond the extent to which many states' tort law allows. The current PPA terms legally obligate non-federal sponsors to undefined and unbound operations, maintenance, repair, rehabilitation, replacement for water resource projects. This is challenging for non-federal sponsors legally to assume because the obligation extends well beyond the period of analysis and project life. This policy essentially creates a permanent federal hold on non-federal property. The liability terms are problematic for cost-share sponsors in all core mission areas: water supply, flood damage reduction, disaster recovery, and ecosystem restoration. Although agreements have been executed and signed in many areas, that does not mean that they're problematic for non-federal sponsors. Sometimes non-federal entities, states, interstate organizations, local entities, or private organizations will make the tough choice between securing financial resources to resolve a very important water resources problem over their own challenges in accepting the complete and total liability and assuming requirements in perpetuity. Sponsors for flood management projects and water supply projects often use their revenue source to partially offset the one-sided liability of the project terms and have to accept the consequences of perpetuity beholden to the federal government for the project structures. We must ask whether this is appropriate. Is shifting the liability from a national tax base solely and completely to a smaller tax base appropriately, especially if the project is found to be in the national interest? And who is that tax base? Is it equitable for the federal government to push the complete risk to the non-federal sponsor, whether a state, local government, or private organization? Non-federal sponsors for ecosystem projects often do not have an associated revenue source for the project, so executing the agreements is more problematic. In 1986, Congress recognized the need for local sponsors to have greater financial and decision-making roles and established a new cost-share formula. My understanding is that the federal government was risk-averse to implementing flood projects on non-federal lands, and Congress added a requirement that non-federal sponsors fully indemnify the Corps. Since then, we have gained substantial experience in these non-federal cost-sharing partnerships, and we better understand the implications to non-federal sponsors. We are now asking Congress to reform this provision to create a more equitable approach to sharing risk. This request is not to free non-federal sponsors from liability, but rather have the Corps share in that liability. We acknowledge and underscore the value of our relationships with our partners within the Corps who are working earnestly to advance important projects. These policies tear at the fabric of our partnership by creating unnecessary conflict and inefficient use of staff and other resources, ultimately delaying and in many cases preventing critically important benefits to the public. In closing, my colleagues and I are here today to urge you to remove or modify unreasonable requirements that currently restrict or deter non-federal entities from participating as cost-share partners. We believe that reasonable and equitable partnerships will increase opportunities to leverage non-federal investments to achieve local, regional, and national water resource goals. We call upon Congress to revise these statutes for which the Corps is using to justify these provisions, and we offer our assistance to work with you in resolving the impasse. As Congress and the federal government continue to prioritize non-federal cost-share projects, we believe that these issues to PPA execution must be resolved so that existing and newly authorized projects to be successfully and efficiently implemented. Thank you.
Thank you very much. Last but not least, we're going to hear from Bren Haas. You pronounce your name Haas, right?
I do, Senator.
All right. I understand you're the executive assistant to the governor of Louisiana. Who is the governor of Louisiana?
Governor John Bell Edwards.
You're kidding. Okay. I spoke to you earlier about him. Give him our best. He testified, if I'm not mistaken, before this committee about a year ago.
That's right.
I think he sat in that very seat. And so that's the Louisiana seat. But he's one of our favorites. Love it when our recovering governors come to the Senate too. I understand you're the executive assistant to the governor of Louisiana for coastal activities. Is that right?
That's right.
Coastal activities. And the chairman of the Coastal Protection and Restoration Authority Board. Prior to this role, you served as the Deputy Executive Director and Division Chief of Planning and Research for the Coastal Protection and Restoration Authority. And I understand that you're the lead author of the Constitution of Louisiana. No, that's a typo, I'm sure. You're the lead author of the 2017 Louisiana Comprehensive Master Plan for a Sustainable Coast. That's a mouthful. But we thank you for that, and we thank you for being here today and participating in this hearing. We're looking forward to learning from you and other witnesses in the next hour or two. So thanks. Welcome. Your retirement statement will be made part of the record. Go ahead.
Well, thank you for that, Chairman Carper. I'll be happy to relay those pleasantries to the governor. I'm sure he would extend the same to you as well. Ranking Member Capito, members of the committee, thank you for the invitation to testify today to provide feedback on the U.S. Army Corps of Engineers project partnership agreements. As you mentioned, my name is Bren Haas. I have the honor of serving as Executive Assistant to Louisiana Governor John Bell Edwards for coastal activities, as well as Chairman of the Board for the state's Coastal Protection and Restoration Authority, or CPRA. CPRA was created by the Louisiana legislature specifically to partner with the Corps of Engineers on coastal protection and restoration projects. Our mission is to provide both hurricane protection and ecosystem restoration for South Louisiana. A strong partnership with the Corps is essential for coastal Louisiana to meet its coastal protection and restoration goals. And we successfully partnered with the New Orleans District of the Corps to deliver some of the most transformative coastal infrastructure projects in the nation. Since its establishment in 2007, CPRA has signed approximately 15 PPA-related agreements and 25 feasibility cost-share agreements, design agreements, or memoranda of understanding or agreements with the Corps of Engineers. These cover a variety of project types, and our experiences with them inform my testimony today. To that end, I'd like to emphasize 5 key points. The first of those is the inertia of the status quo. This is often experienced by CPRA when negotiating PPAs with the Corps. We're generally presented with a take-it-or-leave-it scenario, a model agreement that may not be best for either partner or most efficient to advance a project. The alternative generally is to negotiate changes to the model PPA through the district, up through the division, and all the way to headquarters, a prospect that can be difficult, confusing, and of course cost precious time and money that none of us can afford. Non-federal sponsors should be true partners, able to provide meaningful input on the terms of partnership, on the terms of the partnership. More flexibility should be delegated to district commanders to negotiate provisions that make the most sense for delivering projects as efficiently as possible. Second, land rights. Acquiring real estate rights and full fee title is impractical and not reasonably needed for many projects. Over 80% of coastal Louisiana's wetlands are privately owned. To achieve widespread coastal protection and restoration, we must partner with those landowners, most of whom will give the necessary land rights to complete coastal protection and restoration at no cost. We've been doing such projects in Louisiana for decades without acquiring property and fee title, and it has worked. There's no reason we can't do the same in partnership with the Corps of Engineers. Third, I'll hit on O&M. There are several acronyms that have been used in deference to the chair. I'll not go through that again. Certainly, we share the comments.
The chair wants to thank you for that.
We certainly share the concerns expressed by my colleagues here. There are other problems, though, that sometimes arise related to O&M and project design or construction, which are generally led by the Corps of Engineers that can carry over into a finished project. Because the terms in most PPAs, the Corps can require the non-federal sponsor to conduct the operations and maintenance for such deficient projects. The Corps shouldn't be able to transfer a project with problems to a non-federal sponsor, particularly when those problems have been identified previously during design or construction of that project. We also at times have paid for and conducted operations and maintenance on projects that are fully funded by the Corps because they lack the necessary funding at the time to complete those activities. PPAs are generally silent on how to treat those expenditures. It would be helpful to have provisions to allow the non-federal sponsor to receive credit against those expenditures for such works. Fourth, indemnification. This has been discussed a great deal, and I'll just reiterate, I guess, that we certainly agree with my colleagues at the table here today and would reiterate that there needs to be a more equitable sharing of potential risks among project partners. Fifth, I'll hit on cost sharing. CPRA, like other non-federal sponsors across the country, must ensure that our limited financial resources are leveraged to the full extent. The use of deferred payment agreements, crediting MOUs, and the ability to perform work in kind have been extremely helpful in partnering with the Corps in the recent past. That said, some aspects of cost sharing can be a challenge. Financial transparency provided through PPAs is essentially a one-way street. The Corps can examine the books of the non-federal sponsor in detail, while the non-federal sponsor has no such reciprocal ability. As a result, the non-federal sponsor has to meet an unknown cost share requirement, as has already been discussed. It just makes common sense for this arrangement to be reciprocal, since both partners are bearing the cost of implementing these projects. So in conclusion, CPRA recommends this committee encourages the Corps to advance policies that align with the following two general principles: giving greater voices to the non-federal sponsors and increasing transparency. To do so, we suggest greater delegation of authority to district commanders to negotiate PPAs while allowing for streamlined appeals to higher levels of the Corps when needed. We certainly appreciate the Corps for being one of CPRA's most important project partners in our mission to protect and restore Louisiana's coast. We've been tremendously fortunate to be able to work with the New Orleans District, which has put on the ground some of the most transformative Corps projects across the entire nation through these agreements. And CPRA is confident we can work even more productively with the Corps to deliver projects for our state and nation with improved PPAs. Thank you for your time and for your attention. Look forward to your questions.
Thank you for your testimony. Great to see you, and to welcome all of you to today. The first question I'm going to ask is for all the witnesses. This is a question I'm going to come back and ask you to answer for the record, and not today, but for the record. Because I think in your testimony, you've already begun to answer fairly well. But the question that I'm going to ask you to answer for the record, would each witness briefly elaborate on the challenges and opportunities you see in partnering with the Corps? Your views are particularly relevant as we're beginning to develop WRDA 2024. And if you'll just do that for that, we'll have some other questions for the record, and I'll talk about that at the end of the hearing. As my colleagues know, I'm always, in fact, we're always looking for when we have a diverse panel. We're looking for a consensus, like where do you agree? And sometimes people think, well, repetition is a bad thing. Not necessarily. If the three of you came in and as you've been pretty consistent talking about cost shares and what if there's cost overruns, who bears the responsibility? I think there's a lot of agreement on some of the indemnification issues. But let's just start off, and we'll start, Mr. Hague, with you. And just pick maybe three areas where you think, important areas, where you think there's consensus amongst the three of you. It's critically important, and we should take seriously those points. Go ahead. Just give us three good ones.
Absolutely.
And again, repetition is not a bad thing.
Absolutely. And I will repeat a lot of the things that I think you've heard from all the witnesses today, and plus included in my statement. I think the hold and save clause, as you've heard, is particularly problematic for all the sponsors to agree to. That really does seem to be an unfair balance of a legal liability that we're forced to take on as sponsors of these projects, to that unbounded nature of the operations and maintenance commitment, which I should also point out, you don't always fully know the extent of that commitment until the project is fully constructed and the Corps presents you with the operations and maintenance manual. So you have to agree that when you're signing the agreement, before construction even starts, to this open-ended O&M obligation. Those would be the two high points, really, that I would emphasize, and would love for you to focus on in this next Word of Bill.
Yeah, I want one more. You can think about it, okay? And while you're thinking, we'll just turn to Ms. Wallace. Go ahead and you turn on your
Thank you.
microphone.
I agree with Mr. Hague. The indemnification hold and save clause is critical to reforming as well as unbounded operations and maintenance. And to echo Jimmy's point, you sign onto those agreements when planning is at 35% done, and the Corps remains in control of the rest of the project and who the construction contractor is, et cetera. So those two issues are really necessary for Congress to act.
You have one more. Think about it, and we'll come back to you, okay? All right. You don't get out of here without a third one. Mr. Brennan Haas.
Yes, sir. Yes, sir. Thank you, Senator. Yeah, I would add to those, I think, the point that I brought up in my oral testimony related to the transparency and what a final bill might actually be. So we talked about cost overruns, increasing costs associated with negotiating PPAs, but also in project implementation. And it's often difficult for the non-federal sponsor to get a very clear picture of what essentially the bill due will be. And there's a theme, I think, related to all these three issues, and that is certainty and predictability. All three of these things relate to uncertainty, which increase risks, obviously, on the non-federal sponsor in delivering these projects and be able to make good on the commitments that we make by signing those.
Okay. Let me stick with you, if I can, for just another minute or two, Mr. Haas. I think one of my questions was, I was going to ask you to please let us know what you think that the Coastal Protection and Restoration Authority considers before signing an agreement with the Corps. I think you've spoken to that. So I'm going to do a follow-up. How do you strike the balance between moving quickly and moving deliberately to advance large-scale coastal restoration and protection projects?
Sure, that can be a difficult balance to strike, as you all certainly are aware. As I mentioned again in my oral testimony, sometimes we feel like we're stuck with a sort of take it or leave it kind of approach, where we have a model PPA before us. There's a tremendous need across the country in all of our states, certainly in Louisiana, where we've experienced natural disasters just like other parts of the country. There's a tremendous need to respond to those and protect our citizens from storm surges, flooding, and restore our ecosystem for all of the reasons that that's important. And so there's a calculus that has to be gone through essentially to evaluate the risk of delaying those kinds of projects and having citizens remain at risk into the future, or going ahead and in some cases basically holding our noses and agreeing to terms that we might not particularly want to agree to, so that we can get projects done. And so there's no science to that. That's probably more art than science, but in general, we have moved forward where we needed to for the good of the citizens of the state of Louisiana to get projects on the ground that will help reduce risk to them and improve the ecosystem in which they live.
Good, thanks. I'm going to go back real quickly. Mr. Hague, I gave you and Ms. Wallace the opportunity to give us 3 areas where you think there's a great deal of consensus and agreement. You have one more, each of you have one more, so don't pass it by. Go ahead.
I would love this committee to look at cost flexibility and meeting the cost share requirements. In the last Word of Bill, you did tackle this a little bit, and allowing sponsors to use other federal funds that meet complementary purposes of the project. The other place I would love for some attention is when sponsors have material that they've received as a donation that can be applied for the purposes of the project. A lot of times the Corps doesn't give the sponsor full credit for bringing those materials to a project, and that could be a simple thing for this committee to fix in the next Word of Bill and give sponsors a lot more flexibility in how they meet the requirements.
Good, thank you. Very briefly, Ms. Wallace, one more shot.
Lean into partnerships, encourage the Corps to provide collaborative leadership along with the local sponsor.
All right, thank you. Senator Capito. And after Senator Capito's asked her questions, we're going to turn to a senator from another large state, Rhode Island. And Senator Whitehouse, welcome today. And then Senator Ricketts. Thank you.
Thank you. Mr. Hawes, you have in your capacity or prior capacity have actually negotiated one of these PPAs, is that correct? More than one?
Yes.
Okay. When you've had a disagreement, and you say that you have to work out, you get the model and then you try to, what's the length of time to try to overcome that disagreement? Does it ever get to the point where you never really do? How have you worked those out in the past?
Yeah, so we do have a lot of experience in negotiating those, Senator. Thank you for the question. It can take quite a long time. It can take months to negotiate the terms of these agreements, of course, and that's where sort of the calculus of weighing the advantages, perhaps, to negotiating better terms for the non-federal sponsor on these agreements. Does it outweigh the potential risk, of course, of not getting a project done or having that project being delayed and those costs being increased or perhaps become infeasible in some way? But in terms of kind of the mechanism for negotiating those, we work very closely with our local district, the New Orleans district, obviously, to try to negotiate those terms. At times, we've had to bring those negotiations to the division and then again up to headquarters often as well.
Have you ever walked away from one? Have you been able to get the disagreements put to rest?
I don't know if we've ever walked away from one. That is a good question. I'm not aware that we have. We have signed many under duress, I would say. But I don't know that we've walked away from it. I have to get back with you.
Okay, I was just curious. And then if you were a first-time non-federal partner looking at this, what one piece of advice would you give a first-time applicant to become a partner with the Corps under these circumstances that we have now?
If I might take the liberty of mentioning two things,
Of course.
I would say be aware of what other non-federal sponsors around the country are agreeing to. Know what those other agreements look like around the country to learn from those experiences and the negotiations that other non-federal sponsors have gone through. And then secondly, I would say it's imperative to have a very good working relationship with your local district, the district commander. They, of course, are the ones that will elevate disagreements to division and to headquarters, and they can be your best advocates at times. And so having a good, trustful working relationship with the districts is very, very important.
Okay, thank you. This is for the panel. This is on the hold and save language. I mentioned in my opening statement, and we've gone through this, but I'm going to dig down a little bit into it, that the 86 law requires that PPAs to include hold and save language. This language indemnifies the Corps except for when damages are due to the fault or negligence of the Corps. So in thinking about this, I'm trying to think, Mr. Haig, I'll go to you first. What kind of circumstance could occur that would not be fault or negligence that would be an exception where the liability would fall to the non-federal partner?
Thank you for the question.
I mean, I'm just trying to figure out, envision this.
Right. It's a difficult question to answer, I think, with specific examples. When I've talked to lawyers about the hold and save clause, in a lot of ways, they're most worried about those sort of unforeseen and unimaginable instances, which is why it's particularly problematic, because it is a perpetual indemnification of the federal government for any reasons except where the non-federal sponsor, who has the burden of proof, can show that the Corps was negligent. I think that requirement is particularly problematic for non-federal sponsors for a couple of reasons that you've heard from today, one of which is the Corps does retain a lot of the authority for final decisions around planning and execution of these projects. So when you have a situation of a partnership where one partner has to one partner of the Corps has so much control over project design and execution, and the other partner has to indemnify them and have the burden of proving fault or negligence, that's a really tough balance to swallow for a sponsor, not to mention some of the state law objections that you've heard mentioned as well. So that creates specific challenges for states where those conflicts exist.
Right. Ms. Wallace, do you have any examples or things that you've thought of or your group's thought of that might hold to these exceptions?
Yeah, and I think Mr. Haas can answer that question. I think he's got examples. ICWP doesn't have examples like that we would want to speak to, but I can say from a state perspective that it still would conflict with the constitutional law for states to sign up for an unknown cost at an unknown time for an unknown reason.
Okay, so the states in red that have conflicts, do they still go through with PPAs, or they're just absolutely prohibited because they have to sign this agreement?
Some have, for the same reason that he spoke to, which is that you stand in between a federal resource, federal
Right.
dollars for an important project. But more and more states are saying we can't do
Okay.
this.
Okay, Mr. Hawes, do you have an example?
I do, in fact. And so a tangible example of this would be for projects that we've been involved in where pile driving, for example, was involved. And so through the normal course of pile driving, even if it's done correctly, there can be damages to adjacent properties. It's been our experience that the Corps has viewed that as being, that liability as being indemnified, essentially. We believe that should be a project cost. It's something that occurs in the normal course of doing business, of constructing projects. And again, we think it should be a shared project cost, not the responsibility of the non-federal sponsor.
All right, thank you. Thank you for that example. Thank you.
Thank you, ma'am. Senator Whitehouse, welcome. Good to see you.
Thank you very much. Thanks for doing this. I think particularly as we see sea level rise accelerating, our coastal states have a real sense of urgency about making sure that we can work effectively, timely, and fairly with the Army Corps of Engineers. And I would reiterate what I have told this committee before, which is that the flooding funding of the Army Corps of Engineers tends to be heavily, heavily, heavily biased towards upland, inland river flooding. There have been years in which for every $100 spent on upland and inland flooding, $1 was spent on coastal flooding. And when you look at what climate change portends for coasts, when you look at what our map in Rhode Island shows our coast is going to look like in the decades ahead, this is a very, very serious problem, and we need to make sure that the Army Corps is going to be responsive to it. Let me particularly welcome Brenna Haas here because he was kind enough to have dinner with Senator Cassidy and myself when I visited Louisiana, 4 years ago now, to look at the work going on down there to respond to Louisiana's rather spectacular loss of property to sea level rise. And I was grateful for his time and expertise then, and I'm grateful, sir, for your time and expertise now. It's good to see you again. I hope all is well. We've heard about the sponsor's share requiring a certain amount of investment and risk, cost overruns adding further potential investment and risk, maintenance and operations being delegated to the sponsor, adding further financial exposure, and liability opening up an unknown can of potential risk worms. In addition to that, it strikes me that even with all of those difficulties, if you could plan in an orderly way through time what an Army Corps project was going to look like and how it was going to roll out, that would make it a lot easier on the local sponsors. My experience has been that the timing of Army Corps projects is very much also uncertain often, and certainly unknown when you try to begin. And so you have the additional variable of not knowing when you're going to have to spend the money, in addition to not knowing how much you're going to have to spend in all of those four areas. Is that an observation that is unique to Rhode Island, or is that an observation that you've seen in your worlds as well? Mr. House, let me start with you.
The short answer to that question is no, it is not just an observation from Rhode Island. It's certainly something that we've experienced as well. The win, again, is an extremely important factor in all of this and gets back, I guess, to the theme that I mentioned earlier, really, which is predictability and certainty on all of these things. And with less predictability comes less certainty that we're going to be able to be good partners and deliver what we have agreed to deliver on. So, no, that is something that we certainly have experienced in Louisiana.
You've mentioned that when the Corps is a partner in a project, the Corps can seem inflexible and overly committed to the status quo. I think that's a very important signal, particularly when the future is unknown. You don't know how quickly things are going to roll out. It can be very hard to get into the core bureaucracy and get real responsible answers on any kind of a reliable or timely basis. The last thing I'll mention, I see my friend Dan Sullivan here who does not quite have this exact problem, but small states and communities that have big projects. The other question here is what I think banks would call leverage. If you're the state of California, if you're the state of Texas, if you're the state of New York, and there's a very significant Army Corps project that goes in and you're the sponsor, the non-federal sponsor, then how that turns out as a percent of your state's budget or a local community's budget, it can be a very minor thing. And if it triples or doubles or gets moved from year to year in ways that you can't control, that's a little bit more manageable. But Rhode Island is looking at having to build an entirely new hurricane barrier to defend our capital city from predicted flooding that will flood right through the downtown business zone, so that existing buildings will be underwater, not in the upper stories, but their front doors should be underwater. The main entrance to City Hall is up a grand staircase. Well, the grand staircase is predicted to flood up to a certain point, so all the operating doors along the sides that people use would flood out, and you'd presumably have to arrive at the City Hall of Providence stairs in a boat and climb your way up. So getting that fixed by having a proper hurricane barrier is a really big deal. That is going to be enormously, enormously expensive. And so for small states with huge projects, we have a real problem that I'd like to flag as I close out. Thank you, Chairman.
Just to reiterate the point that Sheldon's making, I don't know if this is correct or not, but I've been saying it for years. Every 100 minutes, they lose a piece of land in Louisiana the size of a football field. Is that still true?
Yes, sir. On average, that is true.
Well, that's amazing. That is incredible. Okay, I need to take a phone call, and I'll be right back. Senator Capito is going to preside for now, and I'll be right back. Thanks very much.
All right, Senator Ricketts.
Great. Thank you, Chairman Carper, and thank you, Ranking Member Capito, and thank you for our witnesses for being here today to share your perspectives. I have often talked about the Army Corps of Engineers and my problem when I was governor about their performance, from anything from how long it took them to issue permits to how they were managing water storage that actually increased the chance for flooding, and then what they were doing with regard to flood control. And so I'm anxious to use WRDA to improve the governance of the Army Corps of Engineers, and especially focusing on the fact that these projects need to be led by natural resource districts, municipalities, and local communities. Flood control, in my opinion, needs to be the first priority for the Army Corps, and especially along the Missouri River, and they should not be undermining that. Before I get into some of these other topics, though, one of the things that the Army Corps of Engineers has rolled out is their permit finder. And as we review the permit finder, we looked at, it seems to be outdated already and lacks updates. And if we're going to be able to manage these projects, it seems we've got to have the proper information in there to be able to, and that needs to be prioritized, these tools to monitor the progress. Just for all the witnesses, I'd just love you to share your experience with the Army Corps' permit finding database, and just have you tried to navigate this, and what's been your experience? So you, Mr. Hague.
Senator, thank you for the question. I do not have experience navigating the permit finder just yet, but I'd be happy to follow up with our conservation staff on the ground to see if they've had and report back to you. That'd
be great. If you could, I'd appreciate it. Just contact our office. Just kind of what your, I'm not looking for a big, long essay. I just want to kind of know what's your experience with it. Ms. Wallace?
We've also not had experience with the permit finder database. I didn't know it existed.
Oh, okay. You didn't even know it existed. Okay, maybe that's part of the problem with the Army Corps of Engineers. They need to get that tool out there. Maybe that's why they're not updating it, because nobody knows it exists. Mr. Haas.
Yes, sir. Thank you, Senator. We do have a little experience with the permit finder database, and have found it actually generally to be relatively good in our case. Most of our permits and our actions that are pending are included in the database, and we're able to find those and query those well.
Well, I would also note that while I've had problems with the Army Corps in the past, the relationship between the state of Nebraska and the Army Corps is improving with the leadership we've had there for the last couple of colonels that have come in through, so that's been a good deal. I think we got Colonel Hudson, Colonel Neubauer have all done a good job. All right, so Ms. Wallace, you were talking a little bit earlier about project partnerships, especially for small local communities. How does the current PPA structure deter sponsorships? You know, in Nebraska, we have primarily natural resource districts, which we've got 23 of them across the state. They're all locally funded by property tax. How does the current PPA maybe discourage something like a small entity like that from getting involved in a PPA?
Well, exactly. I think on one side you have federal investment that meets what the local entity can put together for an important water resource project. So you have a lot of energy towards and motivation towards signing that PPA. On the flip side, you have long-term consequences of fully indemnifying the federal government and taking on perpetual O&M, basically having a federal hold on your property and your tax base. It's shifting from a larger tax base, that consequence, to a much smaller tax base for a project that's in the national interest. So that comment earlier rang true. Who is that tax base and can they afford it, the project?
Right, so maybe you can expand upon that a little bit, just about if you're a small taxing base and you're attempting a big project and you have to take on full liability for the operations and the maintenance as well as any sort of problems, especially, you said, right, 35% the way through the project, you're actually taking this on. Talk about that a little bit more if you could. Like, have you seen specific instances of that where communities or small entities have said, hey, we're not going to do this because it's just too much? Oh, your microphone.
Oops, sorry, excuse me. We have had states, organizations, entities say they cannot sign a project partnership agreements because of the unknown cost and time of that cost, the reason for that cost, and what that means for them long-term financially.
And in your estimation, would some of these projects be in the national interest as you've described before?
Correct.
Yeah. So the idea here is that we've got small entities where you're taking the local property taxpayers, in the case of Nebraska, would have to take on these huge responsibilities to be able to meet the current requirements, and that's just not going to be possible sometimes. So maybe
Exactly.
projects that are in the national interest are not being done because of the requirement to have that local participation. Is that fair?
That's exactly correct.
All right, great.
Thank
well,
you.
Thank you very much, Ms. Wallace. Again, I think that Mr. Haas also mentioned this about just the flexibility, having flexibility with the Corps. Certainly my experience as governor was the Corps often has its rules and does not feel like it has the flexibility to be able to change those, to get up the chain of command, takes time, all that sort of thing. So I think there's some opportunities here for us to be able to take a look at that and see what we can do. And I appreciate your comment about having the local districts have more flexibility in negotiating these agreements because they're the ones that are on the ground there. And certainly when you've got local entities, they know exactly what their communities need. So I think more flexibility would also help us be able to get that done faster. So thank you.
Thank you. Thank you. Senator Cardin.
Thank you, Madam Chair, and let me thank our witnesses. Army Corps projects are critically important to my state of Maryland, and we recognize the challenges with project partnership agreements. So Senator Ricketts mentioned as many the loss of opportunity because of the affordability and risk factors that we're not able to take full advantage of the opportunities of the Army Corps projects. I want to take it from a little bit different angle. These projects, in many cases, have also national significance. It's not just the local benefit of the project to the entity that is submitting the project, but also to our nation. The Chesapeake Bay, I've talked about many times in this committee. It's a national resource. It's a national treasure, largest estuary in our hemisphere. And it's endangered, and it requires constant attention. So we've had Army Corps projects with partnership agreements to deal with the Chesapeake Bay. The largest, from the point of view of the economic impact, was Poplar Island. It was novel at this time. The first environmental restoration using dredged materials in order to restore an island on the Chesapeake Bay. If you go back 100, 150 years ago, there were several habitable islands in the Chesapeake Bay. They're almost all gone because of erosion and weather circumstances, et cetera. Poplar Island at one time was habitable. It was down to just a few acres, and we restored it through using a dredged material. through an Army Corps project, through a project partnership agreement. And it is critically important for the economics of our region because we're keeping our harbor and the channels dredged at the proper level and having a place to dispose of the material that is not only without controversy, it's popular. People want it. But at the same time, we're restoring an environmental island that is now a major area for migratory birds. It's restored wetlands, which are critically important to filter the pollution in the bay. And it has just all these positive impacts. Now, we're just about at capacity at Poplar Island. We now have Mid-Bay, and Mid-Bay is now moving forward. Another island that disappeared that will be restored, that will have benefit for the economics of the ports that are through the channels, but will also have a major impact on our commitment to our environment moving forward. So, Mr. Hague, I asked you this question. Yes, I'm sensitive to the needs of easing the liability requirements, but shouldn't there be special consideration given to those projects that have a national significance, such as environmental restoration? I know that the Nature Conservancy, that's your mission. Shouldn't we be having some considerations given in these partnership agreements when there is more than just the local benefit from the project?
Senator, thank you for the question, and thank you for your championing the Bay. You're exemplary in that role, and certainly we've worked with you and your office over the years on a variety of Chesapeake Bay work with the Corps. Nature Conservancy's been involved in oyster restoration in the Bay for many years with Virginia DNR and Maryland DNR and Virginia Marine Resources, and that's a global model for how to do oyster restoration. The reusing dredge material, like you said, is an excellent opportunity to align where that dredge material is coming from in the Bay versus where it should go or can go for a lot of the multiple purposes that you've identified. So we appreciate your support for all those options with the Corps in the Bay. On your question, there certainly are examples of Congress looking at restoration projects and saying it is of national significance and should be a federal function and making those costs 100% federal. And as you were thinking about reforms to the PPA, that could be a way to look at it. That a lot of these projects are unique. Some of them are of these national significance and may be very amenable to the kind of approach you're talking about for nationally significant eco projects.
And I might point out, oyster restoration is another good example where we use partnership agreements. Blackwater, trying to restore wetlands in Blackwater through the use of dredge material. All those are Army Corps type projects that could be subject to considerations as to its importance to our nation, not just to the local community. Blackwater is a national refuge, so it's not really local from that point of view, and we will be looking at those types of considerations. Thank you, Mr. Chairman.
Senator Cardin, thank you very, very much for not just for joining us, but for being a highly valued member of this committee. I would say to our witnesses, we talked a little bit about the backgrounds then, and Senator Sullivan, the witnesses were good enough to share with us where they're from and a little bit about themselves personally. And I just would say to turn the tables here, you got three people sitting up here who are retired military and retired Marine Colonel. Senator Kelly, retired Navy captain. And last time I checked, I'm a retired Navy captain. So there's a pretty good, and we just celebrated about, a month or so ago, I think was the anniversary of the birthday of the Marine Corps. So it's a big day. But then in order to get someplace, the Navy provides the transportation for the Marines. The last time I checked. All right, Senator Sullivan.
Thank you, Mr. Chairman.
That was my introduction.
Yeah, I appreciate that. Well, I'm going to tee up a more specific question that we've been working on here with the chairman's good help. But Mr. Hagee, I'm interested in the Nature Conservancy's view on this in particular. It's something I'm working on with Senator Kelly right now as we speak. But this involves indigenous lands, tribal native lands in Alaska. In 1971, Congress passed what's called the Alaska Native Claims Settlement Act, ANCSA. I won't go into all the background, but it's the largest indigenous land claims settlement probably in the world, certainly in America. 44 million acres of land in Alaska went to the native people to manage and own, actually in fee simple. It's not like the lower 48 reservation system. So very innovative, helps with, development of these communities. Unfortunately, Congress gave a lot of this land, 44 million acres. I think that's bigger than almost every state in the country. A lot of the land was contaminated, like severely contaminated. So here you go, Native people. Here's your land, settlement. Oh, by the way, it's completely contaminated. And believe it or not, for years, the EPA under CERCLA was going to hold these Native communities and Native corporations liable for the pollution. Like, we're going to sue you to clean up the land that we gave you that was polluted. Okay, now that was absurd. It took a bill, Senator Carper and I got passed in 2017 to say, no, come on, feds, don't be stupid. The Native people are not liable for cleaning up contaminated lands that the feds gave them contaminated. Okay, so we fixed that. Only took several years, but I really appreciate the chairman weighing in on my amendment, co-sponsor. He said it was righting this wrong. So here's the next idea. We all care a lot about mitigation banking, right? My state has 65% of all wetlands in America. So these are big issues for us. But we are trying to work with the Corps and this committee to get legislation that would say, okay, when you do mitigation banking, right, on wetlands, if you're doing that, and let's say you actually are mitigating in terms of a cleanup of a previously contaminated land in Alaska, that would count with the Corps. It's complicated, but it's an innovative idea, because the idea that the feds are going to come to Alaska and clean up all this contaminated land that they gave the Native people, it's probably never going to happen, because it's literally in the tens of billions, if not hundreds of billions of dollars. So it's not going to happen. We got to get some cleanup from the feds. But this is an innovative approach. So Senator Kelly and I are looking to introduce legislation that would have that provision and a second provision championed by Senator Kelly to establish a pilot program to allow the Army Corps to enter PPAs with Indian tribes to allow them to provide full project management control for the construction of eligible projects. So I know you guys at the Nature Conservancy, Ms. Hagee, are good experts on these kind of mitigation banks, but what do you think of an idea like that that helps Native, Indigenous people clean up their lands, but maybe from a source that involves a mitigation bank, not from the traditional way, saying the feds are going to clean up, which they should have. They should have never given the lands 44 million acres. Half of it was polluted. Mm-hmm. But what do you think of that?
Thank you, Senator.
And I know you don't have the details, but in general, you guys do this a lot, and so I'm curious. We want to try and get this over the goal line in the committee, and the chairman's already worked with us. His staff's working on it. It's a big, innovative idea that we think is really important and timely.
Well, thank you, Senator, for the question, and I certainly appreciate your leadership on fighting on behalf of your constituents. I know from our chapter up in Alaska that we have been in contact with folks on this kind of topic, the Brownfields team at the Alaska Native Tribal Health Consortium, I believe.
Yeah.
So we're definitely looking to build a partnership there for remediation of these kind of lands, and so something we're looking into very seriously. And of course, the Nature Conservancy has a lot of experience with mitigation banking nationally, setting up banks and running banks in different states. So it's an approach that we embrace quite strongly as a way to get innovative financing approaches to the kind of conservation work we need to get done, where there's not an obvious source of funding elsewise. So it's a concept I would love to look at if we're able to share the details and report back to you.
Good. Well, we'll do that as a part of this committee's follow-up, but we're working it through the committee here, staff, Senator Kelly and I, and our bipartisan bill on these innovative issues that try to help tribal, indigenous communities that, need help. And a lot of them are unfortunately on lands that are polluted, and then they can't, undertake economic development and other things like that. So we'd welcome your interest and eventually support if you want to take a look at the language we're working on with the staff of this committee. So thank you, Mr. Chairman. It's a big issue that hopefully we can resolve.
Thanks. I appreciate the chance to work with you and your team on this. Senator Kelly, welcome. Good to see you.
Thank you, Mr. Chairman, and Senator Sullivan. I look forward to getting this across the finish line as well. It's really important in the state of Arizona as well. We have 22 Native American tribes and often have similar issues with polluted land or land that needs to be cleaned up. We have had some success with tribes working with the Army Corps. I was with Governor Stephen Lewis of the Gila River Indian community just on Saturday at a football game. The University of Arizona versus Arizona State, you know, the annual in-state bowl game went very well for U of A, not so well for ASU.
By the way, who do you root for during that game?
I have mixed feelings. I live close to the University of Arizona. My eldest daughter is a student at the University of Arizona. My younger daughter is a graduate of ASU. So,
My wife is a graduate of ASU.
great, yeah.
Appalachian
Great school.
State University.
They're both great schools. I'm going to have to get one of those jerseys like Kelsey's mother has, you know, half on one side, half on the other. But hey, this hearing is really important to identify, you know, other ways that the Corps can partner with communities on projects. And one of the things that I've championed with Congressman Stanton, also from Arizona, was the creation of Section 595, the Rural Arizona Water Infrastructure Program. This was about 3 years ago. One of the first things I did when I got to the United States Senate. I'm coming up on being here for 3 years. Gone by pretty quickly. And this 595 helps small and underserved communities in Arizona partner with the Army Corps to build drinking water, water conservation, flood control, and wastewater infrastructure. When he's appeared before this committee before in the past, Secretary Connor has pointed to this program as an example of how the Army Corps can help make investments in the West to respond to long-term drought conditions. There's just one problem here, and that's that many projects funded through this program still do not have finalized PPAs with the Corps. In fact, we have some communities like the city of Buckeye, Arizona, which has been waiting for more than 2 years to finalize a project partnership agreement. And these projects are often rather small dollar projects, usually less than $3 million. And especially for projects that help Arizona communities respond to drought conditions, years is too long to wait. So, Mr. Hague, you mentioned in your testimony that the Nature Conservancy does lots of work with the Corps and local project sponsors. What challenges are faced by local sponsors when it takes years for the Corps to finalize a project partnership agreement?
Well, thank you for the question, Senator. When you have a project that's delayed like that and it takes many years, there's a variety of problems, of course, that could come up. But you do think about the issue of time being money, and certainly with the Army Corps, that's the case as well. I mean, we've been involved in projects where, if there is a very long gap between when a project is authorized, originally envisioned, and when you can sign a PPA and start construction, things like the cost of the real estate necessary for the project can go up dramatically. And we've actually had instances where we've had to come back to Congress and get a project reauthorized at a higher level because of those kind of delays. So the quicker that you can get to signing, the easier it is. And there are a lot of internal obstacles for that. And I think any time that you're trying to negotiate a project partnership agreement that requires going up to, say, headquarters level for approval, we do see significant delays, at least of a year, in how long that review at headquarters takes.
Have you seen communities just get frustrated by this and give up?
I don't have an example specifically of where a community has walked away, but a lot of communities, I think, are either they're faced with a choice of sort of take it or leave it in a lot of cases. They have a great need that they can only achieve through these kind of projects with the Corps, and so they either need to take the the agreement sort of as is and maybe take on terms that they're really not comfortable with, or push for those kinds of higher level reviews that can delay projects for years and drive up the cost of doing business.
What are some of the tools available here in my remaining time that the Corps could use, administrative tools that they could use to sign these agreements?
The Corps has developed a bunch of model agreements, a couple of dozen model agreements. These are different sort of template models that you could use for an environmental infrastructure project like you're discussing, an ecosystem restoration project, a flood control project. There really is a variety of different models. And as long as you're a sponsor and are willing to accept that model sort of as is, you can get it done very quickly. But anytime you want to seek a deviation from that model, even a non-substantive deviation, that's going to require review by the division, and if you're looking for a substantive deviation, that's going to require review by headquarters, and that's where things can really get delayed. But they do have these model agreements and have delegated some decision-making authority from headquarters down to division. So those have helped. But still, anytime you're seeking deviations, it slows things down. And you can't get around the indemnification and operations and management challenges we've discussed here today, either way.
Thank you, Mr. Hague. Thank you, Mr. Chairman.
Thank you, Senator Kelly. Senator Fetterman, I'm going to yield to Senator Capito for a couple of questions, and then we'll come to you next, okay? Thank you. Senator Capito.
Yes, thank you. Thank you, Senator Fetterman. I just have a quick question. We've kind of dug down deep on the indemnity thing, I think, understand that issue. Let's talk about the operation and maintenance responsibility in perpetuity, trying to figure out ways to improve that. So you said, I think Ms. Wallace, you said that, or somebody said that you have to sign these agreements at the 35% design phase. Is that correct? Or is that
Even in planning?
Even in the planning, okay. So how would you improve that besides just wiping the whole thing out, which that's not going to happen, we don't think. So, I mean, what would you say, Mr. Hague, that would have meaningful impacts?
Right. So I believe in your opening statement, you referred to sort of the useful life of the project, and I think that's a concept that might be very helpful to latch on to. We've talked a lot about the operations and maintenance responsibility. I mean, I think in truth, it's an operations, maintenance, repair, rehabilitation, and replacement responsibility. So it's an even longer acronym if you pull it out. And so that final R of that acronym is replacement. And I think that kind of requirement also can be particularly problematic for a sponsor when they're signing a PPA very early on in the process to consider having to replace a project over and over and over again. In our experience, mostly in the ecosystem restoration realm, you could imagine situations where you have a useful life of a project, you've achieved the project purposes, you sort of restore natural functioning, and it would be tremendously helpful for the sponsors if there was a way to tie the end of their obligations some way to that useful life of a project, so that we know going in that there is an end point somewhere down the line.
Okay, good suggestion. Ms. Wallace, do you have a suggestion?
That end-defined period is so important. As Mr. Hague said, there's an obligation, and that obligation is to the Corps per the design manual, the O&M manual. And so
Right.
at
That
some
they give
point-
you at the end, but
they
you
give-
don't impact it. Okay, I got that. too.
Yeah, at the ribbon cutting. And so the question becomes, can the sponsor then decide what to do with that replacement? Or is it beholden to the federal government?
see.
And so at the end of a design period, at least there's a cap on who that obligation is to, if it's to their local tax base, to themselves, or to the federal government.
Mr. Haas, do you have any suggestions in there?
I would reiterate Mr. Hague's comments that the useful, reasonable sort of life of the project is the operative language that should be used.
Is that is that a standard that you can find? I mean, is that something that the Corps, you would say, okay, this dam is going to last 45 years. That's the useful life. I mean, are those measurements out there to be able to figure that out?
They are. The projects that we're involved with the Corps typically have a design life and a period of analysis associated
They
with
do,
them, and
okay.
so that is well-defined, yes.
Okay, thank you. Thank you, Mr. Chairman, and thank all of you. Sorry I have to duck out, but I appreciate it, and it's good to see everybody. Thank you.
Senator Capito, thank you so much. Senator Fetterman, welcome. Good to see you, buddy. Take care.
Thank you.
You're on.
Thank you, Mr. Chairman. Thank you. Wow. Now, I just want to say that I'm a gigantic fan of the Army Corps. Really. I wish I had a shirt that I could say that, but they don't have it in my size. And I live literally right on the Mon River, and I've really seen, the kind of work that you've done. And I've actually been at kind of the ribbon cuttings about that, and just how important the work that you've done. And that has generated another century of commerce on the river. So, and again, thank you for that kind of, certainly I could have never figured out how you get it done, but you guys do, and you get it done. And I'm really in awe of your work. And, also now you've been working with our delegation to work on the lockage on the Allegheny as well, too, how important that is as well. And so we're grateful. And now I'm here to talk about other important issues, that you're involved. Now, I'm the last speaker, and this isn't exactly as sexy as or more interesting on Taylor Swift is dating, but we are here to talk about a really important issue. And in counties all across Pennsylvania, whether it's Clinton or Elk or Northumberland, they have significant issues of acid mine drainage. Not on the tip of the tongue of a lot of Pennsylvanians or Americans, but it's really important in Pennsylvania. And now here I'm grateful to ask you about the kind of support that we would need from the Corps. And that's why I'm proud to work with my colleague, the best senator in Pennsylvania, Senator Casey, this kind of work. So, Mr. Hague, what can we learn from the Corps, from other environmental programs to ensure that the Corps works are effectively working within communities to address this acid mine drainage?
Thank you for the question, Senator. I'm also a huge fan of the Army Corps. We at the Nature Conservancy have done incredible work with them over decades to do ecosystem restoration across this country. And I'm also born and raised in West Virginia, so not too far from your state, and so I really appreciate your focus on the acid mine drainage issue.
Yeah.
It's something I'm familiar with. The Corps is perhaps uniquely capable in this world of doing some of the largest, most complex ecosystem restoration work that there is. And so training the resources of the Army Corps onto the issues of acid mine drainage might be particularly helpful for your home state. Apropos of the topic of this hearing, one of the things I might suggest is thinking again about if there is a way ways to constrain the sponsors of those kinds of projects, constrain their financial or legal risks. And I think particularly with acid mine drainage, where you might have an ongoing discharge of contaminated water, you might want to think specifically about how we can encourage non-federal sponsors to join in those efforts by finding some ways to articulate an endpoint at which they can plan around their financial commitments.
So let me ask, is it limits on the financial resources, or are there laws on the books that are working against that kind of an outcome, or whether some of the abandoned kinds of mines and whatever, is there anything more specific that's driving it?
Yes, and a lot of the problems that sponsors of all projects, and I think this would apply for restoration in the acid mine drainage context as well, do have to sign these project partnership agreements that have several requirements in them that are rooted in law. To hold and save the federal government harmless, in most cases, is something that's rooted in statute, as well as this commitment to doing operations and maintenance on these works is something that is rooted in statute. And so those things would be particularly powerful if this committee could address them in Word at 24.
Okay, and we don't have the time to really drill down on that, but I would like to, I don't do much well, but I do. I hire really people that are a lot smarter than I am, and I have a staff that's very much part of this and very much educating myself. And we would like to continue to have that conversation so we can be most effective in addressing that specifically, what's really at the root of some of these challenges that we have, to be more informed and to be a more effective senator to address this. So thank you. And Mr. Chairman, I have 23 seconds left, and I cede that back to the chair.
Well, I'm going to use those 23 seconds. You talked about surrounding yourself with people smarter than you. When I was elected governor, a former governor came to see me and gave me some great advice. He's an older guy. He's probably about 80 years old by then, Bert Carver from Laurel, Delaware. And he said, Governor Tom, I've been governor like all of a month. And he said, I have some words of advice for you. I said, what are they? And he said, first one is the main thing is to keep the main thing the main thing.
All right.
The main thing is keep the main thing. The other thing he said, always hire people smarter than you. And I've tried to do both of those. And obviously, you come from the same school as I do.
Well, and I'm an honor to be a member of your committee. Thank you.
The honor is ours. Thank you. Thanks for being here today. I'm going to, in baseball, they have a term that says telegraphing a pitch. Telegraphing a pitch, and the way that you hold the ball, the pitcher holds the ball, releases the ball, sort of gives you an idea, the hitter's an idea what the pitcher's throwing. And so I'm going to telegraph a pitch unless somebody, another member of the committee shows up. But the last question I'm going to ask you today is just to see if there's anything else that you would like to add. I'm kind of looking at this hearing, looking back, thinking about what you've been asked, what you've not been asked. Maybe a closing thought or two from each of you will do that. In anticipation of that, let me just say, we talked earlier about I think every 100 minutes, Louisiana loses a piece of land the size of a football field. And I don't know about you, I watched a lot of football over the weekend, and Louisiana's a pretty big state, but you can't last forever at the rate we're going. Having said that, the economy, we don't think often about the good news in this body or maybe even in this country. There's a way to look at things negatively. We're pretty good at doing that. Finding the good news is sometimes buried. But with respect to the economy, it's pretty darn good. And I've been around for a while, and I've seen some really bad economies. You have too. But pretty darn good in the last 3 years or so, something like I've been saying it's like 10 or 11 million. I learned today it's like over 13 million jobs have been created in the last 3 years or so, which is pretty astounding. Our unemployment rate, I think for the last 3 years has been coming in under. Well, the last 2 years have been coming in under 4%. I think the unemployment rate today for our country is about 3.9% historically. That's a really good stretch, and hopefully we can keep it going. Told that our employers in this country have added last couple of years about 240,000 jobs per year. That's almost a month. Think about that, 240, about 250,000 jobs a month for our economy. And the number of people that are unemployed looking for jobs is small compared to the number of jobs that are out there going unfilled. You hear those numbers every week or so from the Department of Labor. GDP in a good month, a good year, 3% is considered really good. GDP growth for this quarter has been over 5%, over 5%. And that's the good news. But the reality is, strong economies don't last forever. Eventually, we fall into recessions. The whole world falls into recessions sometimes. And what we want to make sure is when that happens, the recessions are shallow as can be and short as can be, and we get back on the right track. And one of the ways to make sure that we get back on the right track is to do the kind of things for our countries, for our states that we're talking about here today. And a big part of it is the ability to ship around the world the products, the goods that we create here in all of our states, And without the Army Corps of Engineers doing work to help enable shipping to move through our waterways throughout this country, on our coasts, on our ports, like Port of Wilmington is just one example. But without that, we're not going to come back from a recession as quickly in the future. We want to make sure that our economy remains strong, and the capability of doing even more with less is realized. The other thing I want to say, most of us have heard of the Golden Rule. We're a country of a lot of different religions. As it turns out, every major religion on the planet has a golden rule in it. I don't care if you're Protestant, Jewish, Catholic, Muslim, Buddhist, Hindu, they all have it. And when I give commencement addresses, I say to the graduates, I give them a couple of rules to keep in mind to be successful. I always aim high and tell them to work hard, tell them to embrace the golden rule. And I tell them to don't quit. Aim high, work hard, embrace the golden rule, don't quit. And then I tell them that the golden rule is in every major religion of the world, and something that's in every major religion of the world, maybe we ought to pay some attention to it. And nobody's invoked the golden rule here today, but actually I think part of what we're talking about is treating other people the way we'd want to be treated. And at the same time, making sure that they can have a better life, a better quality of life in states across America. Any last thoughts that any of you would like to share with us before I wrap it up, Mr. Hague?
Thank you, Senator, for the opportunity. I haven't had a chance today to thank this committee enough, I think, for the work you've done to reform these PPAs in the past. That I would refer you to my written statement, which does include several of the improvements that Congress has made to help sponsors through these processes. One of them that I would point out is from Order 2016. We've talked a lot about the operations and maintenance requirement, but that WRDA bill in 2016 did create a little bit of a relief for the operation and maintenance for the non-structural and non-structural elements and the non-mechanical elements of ecosystem restoration projects. And so that might be an opportunity for you in your upcoming WRDA bill to look at leveraging that authority and perhaps expanding it to other project types or the structural elements of ecosystem restoration. I think that's a really good starting point for thinking about ways to give non-federal sponsors some certainty that there is an end date to their financial obligations.
All right, good. Thanks for that.
Thank you.
Yeah. Ms. Wallace?
A
parting thought or two.
Thank you. I want to reiterate appreciation to the committee for this important issue. We're missing out on the benefits of investments on important non-federal lands. We're not fully realizing the potential to improve our nation's water resources because we're limiting the possible locations of those investments. And if Congress does elect to resolve this issue, we could place our investments where the need and resulting benefit are the greatest.
Thank you.
Thank you.
Yeah. Mr. Haas?
Thank you, Senator Carper. Yeah, one thing I would mention that we have not yet today is that it would be good for the Corps of Engineers to update its guidance for local cooperative agreements for local partners. That's not been updated since 1989. If done in coordination with a group of non-federal sponsors from across the country, it might be a good launching pad to implement some of the things we've discussed here today. And then lastly, I would just leave you with the thought that while we're talking about PPAs, we're talking about indemnity, we're talking about some of these weedy things, these are all relate to projects that have real impacts to communities and to economies across the country. And so they're important that we address in order to support all of those things for our states and for our nation.
All right, good, thanks.
Thank you.
Thanks. I said at the beginning of the hearing, if it isn't perfect, make it better. And bipartisan solutions are lasting solutions. As hard as we tried every 2 years when we pass a WRDA bill, it's not perfect. But we know there's perfections out there somewhere, and our determination is to get closer every couple of years to that perfection, and making sure that we're laying the groundwork for a strong economy, better economy, with more people, more jobs for people, and frankly, doing the right thing by our environment. I want to just to close say. We want to give you some follow-up questions. I mentioned we want to submit some questions for the record, as you might expect. And I'm looking at this. It says that by 4 p.m. today, and we'd like to have the responses tomorrow. Well, that's not true. We're going to submit, and I'm going to ask our colleagues to submit their written questions for the record by 4 p.m. on Wednesday, December 13th. That's when we're asking our committee to have their questions for the record. We'll compile those at the committee level working with our friends on the Republican side. We'll send those questions to each of you, and we'll ask you to reply by next year, January 3rd. January 3rd. And with that, I once again want to say my thanks to Senator Capito, all of our colleagues who have been able to join us today, and especially to the members of our staff, committee staff, majority and minority. We wouldn't be able to have these hearings without them. And we're going to take the input that you provide with us here today, and in addition to that, which comes from our questions for the record, and see if we can't come up with an even better word the next time around. Anything else? Anything else? And with that, as we say here, this is in Senate language. This is Senate language. It's a wrap. With that, the hearing is adjourned. Thank you all.